What if the losing candidate for president on November 3rd refuses to accept the outcome? Already we have Hillary Clinton, the former nominee, urging the Democrats not to concede until all legal options are exhausted. And we have President Trump saying, well, we're going to have to wait and see what happens. Is this really a constitutional crisis? I'm going to conduct a law school seminar on all the possibilities of what could happen post November 3rd. I'm Alan Dershowitz, and this is The Dershow. What would happen if the losing candidate in the presidential election of 2020 simply refused to accept the outcome of the election, claiming that the vote was rigged or that there were improprieties? Already we've heard the president, when asked if he would accept the outcome, he said, we're going to have to see what happens. And we know that former presidential candidate Hillary Clinton has said that the Democrats, quote, should not concede the election until all legal options have been exhausted. The gauntlet has been thrown down. What will happen? I'm going to now conduct a law school seminar on all the possible options and what the legal consequences would be if either candidate refused to accept the outcome of the election. The answer, in short, is it depends. It depends on what their position is. If you take the Hillary Clinton position, which says don't concede until all the legal options are exhausted, all she's doing is urging the current Democratic nominee, Joe Biden, to do what Al Gore did in 2000. He didn't accept the outcome of the election until the Supreme Court decided in a 5-4 partisan vote to stop the recount in Florida. He didn't concede, and nobody really urged him. Republicans did, but nobody on the Democratic side urged him to concede. They urged him to continue the fight. In fact, some urged him to continue the fight even after the Supreme Court decided the case, because it was such an obviously partisan decision along totally Republican-Democrat lines. 5 Republican appointees voted to stop the confirmation using very, very questionable legal analysis. The Equal Protection Clause applies to how states count ballots, hanging chads and all of that. It was a stretch. I wrote a book about it called Supreme Injustice, where I went through the opinions of all the 5 justices who had voted to stop the recount and showed that in every single case, they had decided cases the opposite way under the Equal Protection Clause in other contexts. And they went out of their way, the 5 justices, to say, this opinion is only for this day in this case only. It doesn't have precedential impact, because they knew basically it was a power grab. It was a partisan decision based on power. 5 Republicans, 4 Democrats. Republicans win. Bush becomes the president of the United States. So what Hillary Clinton is suggesting is merely what Al Gore did. Nothing wrong with that. Nothing wrong with challenging the outcome of the election in court if you choose to. Previous presidents haven't done that. Richard Nixon could have challenged the outcome of the 1960 election. He honestly believed, perhaps wrongly, but honestly believed the election had been stolen from him in Illinois and several other places, but he decided that the interests of the country should be placed above his own interests. He also wanted to run again, which he did successfully, so even tactically it was the right decision to make. But perfectly appropriate for a losing presidential candidate to take the case to court. Now, has what President Trump said, is it really all that different? He has been asked, will you accept the outcome? And he says, we're going to have to see what happens. Pretty vague. It would be much better if he said, I might not accept it, and I might go to court and challenge it, but I will certainly accept the decision of the courts. If the courts rule that the election was valid, I'm not going to stay in office. He didn't say that. He left it vague and he left it open-ended. And as the result of that, many Republicans, including Republican leaders, have gone out of their way to emphasize that no, there will be a peaceful transition. On January 20th, if he loses the election and the courts confirm that he lost the election, he will no longer be president of the United States, and he cannot expect the backing of Republican leaders if he defies the Supreme Court. But what if the Supreme Court divides 4-4? What if there is no definitive resolution by the Supreme Court? What if you have 4 justices say this was a totally invalid election, the ballots were counted improperly, there was fraud, mail-in ballots aren't constitutionally permissible? I don't think that's going to happen, because the history basically is that mail-in ballots are legitimate. Many states have been conducting elections with mail-in ballots before. Never as much as now. We're going to see more non-polling votes than ever before in history because of the virus. Obviously, I'm not going to the polls. I'm voting by mail. And I think many other elderly people, people who are concerned about the virus, will vote by mail. So there is a difference, if not in kind, at least in degree, between the number of non-poll ballots than in previous years. But that doesn't mean the election is going to be a fraud. Look, one possibility is that the election is so overwhelming, one candidate wins by so many votes and so many electoral votes that there's no basis for a challenge. But we always have to be prepared for the worst case scenario. And the worst case scenario was a repeat of 2000 with virtually a tie in the Electoral College, broken by one state where there are only 500 or 600 votes separating the two candidates, and great challenges to whether or not the polls were sufficiently kept open, whether the butterfly ballot was a legitimate ballot under Florida law, whether the recount would have produced a different result, whether you have to recount every vote in the state or just in contested counties. These are all very, very difficult issues. And remember, this is a key point in our law school class. There is no such thing as a national presidential election. There are 50 state elections on November 3rd. Every state conducts its own election under its own rules and decides who the electors would be. And then the election of the president takes place in December, when the electors get together and meet and cast their votes. And if there is a majority in favor of electors of one candidate, that candidate becomes the president. If there is no majority, the election gets thrown into the House, where the Republicans are almost assured of a victory, because the House votes, the House is now under the control of the Democrats, but the House votes not by members, but by states. Every state gets one vote. And so you need 26 states to win the election. And today, more states are controlled by Republicans than Democrats. The other question is, would you be counting the votes of the states based on the election of November 3rd, or based on who sits in Congress in early January? Probably the answer has to be the December Congress, not the January Congress. But I have to tell you, if I were back teaching at Harvard Law School, I would today start a seminar just on this issue, a what-if seminar filled with hypotheticals. What would happen if? What would happen if? The best way to determine what the law is through the vehicle of hypotheticals. And, people say, oh, we don't want hypotheticals, just give us the reality, give us the real facts. Well, we don't know what the real facts are going to be. We don't know what's going to happen on November 3rd. The one thing that's absolutely crystal clear is that if there is a definitive Supreme Court decision, and probably there will be if there's a close election, the president has to comply with that. And virtually all the Republican leaders have said that. There will be a peaceful transition. This will not be Belarus. This will not be Turkey. This will not be North Korea. The warnings of some Democrats are really over the top. The president will and must accept the legal determination as to who has won the election. And if hypothetically you had a president who refused to do it, his party wouldn't support him. Already, President Trump has been told, yeah, if you want to challenge it in court, we're behind you. But if you were to remain on in office after the court said that you can't remain on in office, you would have no support from the Republicans. I don't think that's what the president is saying. This president has a way of, as one person put it in an interview, pulling the chain of the other party. And he certainly has succeeded in doing that. He's gotten a lot of people really up in arms, not only among the Democrats, but among the Republicans. So I think it would be a good thing if the president were to clarify his position and say, I join Hillary Clinton in saying that we will not, either side will not concede the election until all reasonable legal remedies are exhausted. But once all legal remedies are exhausted, then we will obey the rulings of the court. That's the American way. That's what the framers had in mind. The Supreme Court of the United States was established according to Federalist 78, according to Madison, according to Hamilton, according to the framers, in part to resolve disputes of this kind. They've never had to resolve a dispute like this. In fact, until Bush versus Gore, it was really thought that the courts, but even the Supreme Court, didn't really have a role to play in presidential elections, that the House is the determiner of its own rules, the Senate is the determiner of its own rules. Is the president the determiner of his own rules? No, I don't think so. Again, Hamilton in Federalist 78 said that each house is not the final source on what the Constitution is. The Supreme Court is the final source on what the Constitution says, which is why it's so important to resolve the current issue. Does President Trump get to make this nomination? He's going to make it, whether we like it or not, whether we agree with it or not. He's going to make a nomination, he now says, on Saturday. And does the Senate have an obligation to take up the nomination before the election, or at least before the inauguration? Now it becomes even more imperative, according to at least Republicans, to take up the nomination before the election, because once the election occurs, there are going to be challenges. One of the challenges may be to take the case directly to the Supreme Court, not to go through the state courts, not to go through the federal courts, but to take it to the United States Supreme Court as a matter of original jurisdiction. And there are two options. One, the court will be 4-4, or at least will be 8 justices. Perhaps Chief Justice John Roberts will figure out a way of not making it a 4-4 tie. He has the ability and certainly the will to do that. Or there'll be a 5th justice who might cast the deciding vote. And that 5th justice may be a justice nominated by the Republican candidate, confirmed by the Republican Senate, and whose legitimacy might be challenged by Democrats. So we may end up with the Democrats challenging the legitimacy of the outcome of the election if it's decided by a 5-4 vote cast by a justice picked by a litigant in the case. Namely, the case would probably be entitled maybe Trump versus Biden or Biden versus Trump. Should a litigant in the case, one of the litigants, be the one to have picked the deciding justice in the case? You can't make this stuff up. If I were trying to create a class, assume I was at Harvard Law School 30 or 40 years ago, and I was a little bored, I was tired of teaching criminal law, let's come up with an interesting seminar dealing with hypothetical possibilities. If I had come up with what's going on now, I'd be laughed out of the law school. People would say, that can't ever happen. Well, ladies and gentlemen, it is happening. We are living through what could be a major constitutional crisis. You know, in Israel, they ask people, what's the difference between being a pessimist and an optimist? They say, a pessimist is somebody who says things are so bad they can't possibly get worse. And an optimist says, yes, they can. Well, I'm an optimist, but things could get worse. We could live through a situation where either party challenges the legitimacy and even challenges the legitimacy of the Supreme Court. I hope that doesn't happen. It could, and we have to be prepared for it. And you're going to be prepared for everything if you keep listening to the Dershow, because I'm going to anticipate every problem, every issue that could come before the American people. So stay tuned. Keep listening. You'll hear it straight from me, and as I promise you, you'll never be bored. Now it's your turn to ask me questions or make comments. We'll begin with Alex, Massachusetts.
Hello, Mr. Dershowitz. This is Alex from Massachusetts. I just have two quick judicial questions for you. There are checks and balances for both the legislature and the executive, but not for the Supreme Court. What would you propose for a check on a decision by the Supreme Court? And second question, we saw all those judges blocking the president's orders that he is within his constitutional powers to make. Is that within their legitimate power to override the executive? I'd appreciate your thoughts on that. Thank you. Have a good day.
You're a great student in my seminar. Those are excellent questions. No, there really is no check on the United States Supreme Court, except that the president gets to make the nomination and the Senate gets to advise and consent. So the check occurs before the appointment of justices. Once the justices decide, the only real check is a constitutional amendment. Obviously, any decision of the Supreme Court could be overruled by a constitutional amendment. For example, the infamous Dred Scott decision, which ruled that descendants of African slaves, enslaved people, could never be citizens of the United States entitled to rights under the Constitution. We fought a civil war, partly in response to that horrible, horrible decision. And then, of course, the 13th, 14th, and 15th Amendments overruled that decision. The other check and balance on the Supreme Court is later Supreme Courts. Some of the worst decisions of the Supreme Court have been overruled in subsequent decisions. But if the Supreme Court were to decide the election, there'd really be no check and balance on its decision. As far as executive power is concerned, it's not really expressly set out in the Constitution. Executives are using more and more executive orders. They are obviously subject to being rescinded by the next executive. They have no force beyond the particular presidency. Many have been challenged in court. It's an area of uncertain constitutional dimensions. Great questions. Thanks. Hey, Ron from Texas, what do you have to say?
Three questions, Professor. If the one officer was found guilty or indicted for reckless endangerment by blasting random rounds into a wall that could have hit three different people on the other side, which I think I'm great with that idea. That is reckless endangerment. But the other officers who engaged the gentleman with the firearm who shot at them, they missed him. They didn't hit him, and they killed this other person, Rihanna. Why aren't they charged with something? They own those bullets till they stop moving, and they messed up, and they missed, and they killed this woman. I'm not getting why they're not indicted for that. Thirdly, why isn't the shooter, the gentleman who fired at the officers, why isn't he indicted? In Texas, he would be, I think.
Hey, Ron, great questions. You have a very good point about reckless endangerment. I don't think you're right about the mere fact that they missed the shooter and hit an innocent person. It was dark. One of the officers had been shot. They were shooting generally in the direction of the bullet where it came from, and they may very well have made an honest mistake. If they had the right to shoot the shooter, probably they can't be indicted for shooting accidentally the innocent victim, unless the innocent victim is very far away and her death was a result of recklessness. I was frankly a little surprised that they didn't use reckless endangerment against the other officers as well. And, that's always a possibility. Indictments don't carry double jeopardy. They can be revisited, and the federal government has the right to revisit as well. As far as the shooter, the boyfriend, it really depends on whether he honestly believed there were intruders and he was protecting himself and his friend, in which case he'd have the right to self-defense. At least he'd have the right to an instruction to the jury. If you believe that he reasonably believed there were intruders and he was shooting to protect himself, that's not a crime. On the other hand, if he knew it was police, then he would be guilty of a serious crime. Shooting a policeman is a serious crime. And ironically, he could even be guilty of having killed his girlfriend, even though he didn't fire the fatal shot. Under the felony murder rule, in some states at least, if you fire a shot illegally and commit a felony, and as a result of your firing the shot, somebody else fires another shot and kills your friend or your co-defendant or whatever, under a stretched interpretation of felony murder, you could be guilty. On the other hand, the result that was reached by the Attorney General is not beyond the realm of reason in traditional criminal law theory. And the one thing that I think we can all agree upon is that although crowds and mobs and protesters have the right to express their view, prosecutors and grand juries shouldn't be influenced by what happens outside the courtroom. They should be influenced by the evidence, by the facts, and by the law, and by the traditions of the office. And so reasonable people could disagree about the decision not to prosecute, but I think it's unreasonable to say that it was beyond the ken of all reasonable decisions regarding prosecution. Hey, Harvey in Henderson, Nevada, what's your point?
Good morning. It's Harvey Cohen. I live in Henderson, Nevada. Thank you for your show. I'm spreading the word on social media, get as many viewers and listeners as I can. My question is, can you conceivably see a day where MSNBC or CNN can have on guests that deliberately mislead the public with respect to guilt or liability in, say, like the Breonna Taylor case, where certain people could sue the networks for predicting or getting viewers to expect an outcome that you and Turley and others have made very clear wasn't realistic to begin with? They're inciting violence and rioting, and it's ridiculous. The network should have an obligation to have on legal scholars to present the merits of a case so everybody knows when an obvious solution is coming to be prepared for it and not to riot from an obvious verdict. Okay, thank you. Good luck and have a great day. Bye.
A great question. And in some Western democracies, I think you might very well have a point. Some democracies allow group libel, hate law libel, allow false news to be in some way the subject of a lawsuit. We don't allow that in the United States. You can sue a network. I am suing CNN for defaming you. In CNN's case, they doctored a tape, made up a statement I didn't say, put in my mouth exactly the opposite of what I said, and I'm suing them. And I think I have a very strong case. But there's no basis today in law for suing stations simply for lying and making up stories, even for inciting violence. When we used to have the FCC, the Federal Communications Commission, had a more active role. They used to have rules like the equal time rule or the fairness doctrine. Those today are weakened or non-existent. And so, the best answer is turn the channel. Don't watch stations that give you misinformation. But unfortunately, too many stations give you misinformation. And these experts are not experts. Many of the people who claim to be experts just don't know what they're talking about. They're picked for two reasons. They're picked because they follow the party line of the station, and they're picked because they're kind of attractive, or they have the right identity, or all kind of other externalities. They're picked because they sell soap, because they're good for the commercial interests of the network. But it's really a tragedy how few real experts you see who are objective and neutral. And when I was on CNN and I refused to follow the party line, and I always gave my honest opinion without regard to party, I got banned. They had no interest in having me. They wanted a partisan. I remember once getting a call from NPR, National Public Radio, asking me to take a position on something that was going on in the Middle East. And I said, well, my position is nuanced. It's kind of in the middle. Oh, we're not interested in having you. You have to take a position, one side or the other. And that's what's happened to the media today. And it's a tragedy because the victims are you and me and the American public, and we get misled by ideological news. Today, Walter Cronkite couldn't get a job on a major network. Isn't that a tragedy? Hey, Phil, what's your question?
Hi, Alan. This is Phil. I had a question about what essentially you deem to be the most common misunderstanding of the Constitution. And if it's not the same thing as the next question, what is the most pernicious misunderstanding of the Constitution? or of constitutionality? Would appreciate your answer. Thanks.
I think the most misunderstood aspect of the Constitution is people think that the Constitution provides for the United States to be a democracy. The framers were afraid of the word democracy. They saw what was going on in Europe. They were very worried about a democracy. And so they established a republic with a powerful executive, checks and balances, no location for sovereignty. You can't pinpoint who is sovereign in the United States like you can in Great Britain. The Queen is sovereign, the Prime Minister, other countries, the President, the Chancellor. The United States, it's a process. Sovereignty is a process. And I think that's widely misunderstood. It was Benjamin Franklin who said it's a republic if we can keep it. Look, the most pernicious part of the Constitution was the way it treated African Americans and the way it permitted slavery and the way it counted African Americans as less than fully human for purposes of counting them and allocating seats in Congress. And even though it counted them as only partially human, it didn't give them any votes. So the Constitution was built, unfortunately, on a foundation of discrimination and slavery. It was necessary to do that in order to create a union. And then we fought a civil war, and the 13th, 14th, and 15th Amendments began to remedy that. Then, of course, only men could vote, and only propertied men can vote. It was a very imperfect document, but we're moving in the right direction. We've had amendments enfranchising women, enfranchising young people. Today, we have all kinds of laws on the books prohibiting discrimination, and so we've come a long way. Ken from Calgary, Canada, what's your point?
Mr. Alan Dershowitz, look forward to seeing you on Fox News, hopefully in the very near future. You are a preeminent legal scholar. Enjoy listening to you. Enjoy your legal analysis. Very scholarly. My name's Ken Pretty from Calgary, Alberta, Canada, of all places, long ways away. And who knows, maybe I'll get a call. Anyways, keep doing what you're doing. Take care.
Well, thanks. I've been to Calgary. It's a wonderful, wonderful place. Canada is a great, great country, and I appreciate your support, and I hope Canadians and people from other parts of the world will listen to this show and call in. Always ready to take your calls. Thanks. Hey, Tom, what's your question?
Professor Dershowitz, my name is Tom. I'm a QL at a T13 law school, and I'm kind of sitting here wondering how I'm supposed to have institutional faith in a criminal justice system that we believe to be both just and one that brings us justice. And so how am I supposed to be a student of the law while simultaneously seeing such a glaring example of an utter breakdown of the first order principles of the system I'm studying? Thank you so much. Have a great day.
Well, that's precisely why you ought to be a law student, why you ought to be studying, because we have an unjust system in many respects. Imagine being a law student in 1850, where you had to study decisions that talked about African Americans as being racially inferior and not citizens. One of the purposes of law school, one of the purposes of being a lawyer is to change the system, to challenge the system, to make it more just. The Bible demands that justice must you pursue. That should be in every law school classroom. We have to change, and we have to become better. And so I encourage you to stay in law school, go to law school, expose the injustices, and make it better for your children, my grandchildren. That's what America is about, making things better. Thank you for your great questions. As I've said, I'll never refuse to answer a question on the Dershow, so keep them coming. And as I've also promised you, you're never going to be bored. Call our listener line at 216-710-0050. I want to hear your questions, your comments, your criticisms, and your opinions. Remember, all calls are recorded, and we reserve the right to use your questions and comments on the air. Once again, the listener line is 216-710-0050. I look forward to hearing from you. The Dershow is available on iTunes, Spotify, or wherever else you get your podcasts.